11-year-old killer smiles in court, acting untouchable. Then the judge made history. 11 years old. That's how young he was when he walked into that courtroom. But the moment his feet touched the floor, everyone at the gallery felt it. Something was deeply, dangerously wrong. He smiled, not nervously, not fearfully. He smiled like he was untouchable, like the rules that governed every other child on earth didn't apply to him. He laughed during the evidence. He smirked at the camera. And for months, everyone wondered the same thing. How does a child feel no fear? How does an 11-year-old sit in a courtroom and believe he's won? But what he didn't understand was this. The system was about to remind him that some judges don't forget. And some truths, no matter how young you are, will always catch up. Stories like this remind us that justice doesn't care about age. It cares about truth. If you believe accountability matters, subscribe now and let us know what you think below. Because stories like this one need to be heard. Now, this is how it all began. In a quiet suburban town where everyone knew each other's routines, where children played without fear and neighbors trusted each other with spare keys, something was already breaking. No one saw the fracture. No one heard the moment it started. An 11-year-old boy walked through his neighborhood every single day, smiled at familiar faces, and blended into the landscape of normalcy. But inside his mind, something was different. Something was calculating. The town had no idea that on one ordinary afternoon, when the sun was high and the streets were empty, a crime would unfold that would force an entire country to question everything they believed about children, responsibility, and justice. It would become the case everyone talked about, the case that changed the rules, the smile. That's what everyone would remember first. The juvenile courtroom was designed to feel less intimidating than its adult counterpart. The wood paneling was lighter. The windows allowed natural light to spill across the benches. The judge's bench sat lower, as if to suggest fairness rather than authority. But none of that mattered on this day, because standing before the bench, or rather sitting, his 11-year-old legs dangling above the floor, was a child who understood something the architects hadn't counted on. He understood that fear was a choice, and he had made a different choice entirely. The bailiff stood near the door, hands folded, watching. The prosecutor sat rigid, papers arranged in precise stacks, jaw clenched slightly. The public defender, a woman in her 50s who had seen hundreds of cases, kept glancing at her client as if she were seeing him for the first time. But it was the smile that stopped time. It wasn't a child's smile. It wasn't the nervous grin of someone facing consequences they didn't understand. It was deliberate, almost playful. His eyes moved across the courtroom like he was cataloging the reactions, noting the flinch of the victim's mother, the sharp intake of breath from the press corps crammed into the gallery, the moment when the judge's pen paused mid-sentence. He was aware. Completely, totally aware, and he was enjoying it. This was performance. This was strategy. A child who had orchestrated something devastating enough to land in juvenile court was now orchestrating something equally calculated. The impression that he was unbothered, untouchable. That age was a shield no consequence could penetrate. The courtroom was silent except for the hum of the fluorescent lights and the distant sound of a hallway phone ringing somewhere beyond the heavy doors. Everyone was holding their breath. The judge, a man named Harrison with 30 years on the bench and the steady gaze of someone who had seen humanity at its worst and best, looked directly at the child. just looked. Not with anger, not with judgment, with observation, with the kind of assessment that comes from decades of reading body language, of understanding what a smile like that actually meant. The prosecutor began speaking again. But the judge raised a single finger, asking for silence. The room obeyed. The child's smile faltered for just a moment, a microsecond where the performance cracked, and then it returned, stronger, more confident, as if he had just passed a test. The judge made a note. Later, attorneys would ask what that note said, but Judge Harrison would never tell them. He didn't need to. He already knew this would not be a sealed hearing. This would not disappear into the juvenile system where records were sealed and names were hidden. This would be different. The victim's family sat in the third row, directly behind the prosecution table. The mother was a woman named Patricia, who had spent the last 6 months fluctuating between rage and numbness and the kind of grief that doesn't have a name. Next to her sat her sister, and next to her, Patricia's ex-husband, and next to him, their son, a boy only 3 years older than the defendant. That boy stared at the child with an expression of pure confusion, as if he couldn't reconcile the child's shape with the crime they all knew he had committed. How was it possible for someone that small to cause something that large? Patricia's hands were folded so tightly in her lap that her knuckles had gone white. When the child smiled, she closed her eyes. When she opened them again, her sister was holding her hand. The public defender leaned over and whispered something to her client. The child rolled his eyes, not disrespectfully toward his attorney, but more like he was listening to something obvious he'd already decided. The attorney's face showed the expression of someone who had already lost before the trial began. She had seen it before, the combination of age and detachment that suggested either a deeply disturbed child or a child who understood, on some fundamental level, that he operated outside the normal rules. The prosecuting attorney, a man named Marcus who had built his career on victim advocacy, watched this exchange with the grim certainty of someone holding all the cards. He had the evidence, he had the timeline, he had the footage. What he didn't know yet was that the judge had already made a decision about how this would proceed. The security camera footage had been marked as evidence, and everyone in the courtroom knew what it showed. The timestamp was precise. 2:47 p.m. on a Tuesday afternoon. A child entering a space where a trusted adult sat unaware. No screaming, no chaos. Just the ordinary afternoon light streaming through windows and the mundane sounds of a neighborhood going about its day. The camera was mounted high in the corner, its eye never blinking, never looking away. It had captured everything. And later, when that footage would be played in its entirety, the jury would understand why the child's smile in this courtroom was so impossible, so deeply wrong. Because the child in the footage moved like someone who knew exactly what he was doing. The judge ordered a 10-minute recess. As the bailiff stood to escort the child out, the defendant stood smoothly, never dropping the smile, and walked toward the door with the gait of someone leaving a social gathering, not facing charges that could define the rest of his life. The courtroom exhaled. The mother began to cry, not loud, but deep. The kind of crying that comes from the core. The judge watched it all, and when everyone had filtered out, he sat alone at his bench and read Marcus's motion again, the one that had arrived that morning. The motion that asked for something unprecedented. The motion that asked the court to consider whether juvenile protection statutes were ever meant to shield a child capable of this. The smile held in the courtroom for now, but the judge had already decided it wouldn't hold much longer. The hallway outside the courtroom filled with the kind of whispers that happen when people are processing something their minds haven't caught up to yet. A woman in a gray blazer leaned against the wall and said it aloud. He doesn't understand what he's done. He's 11. He can't possibly understand. Her colleague, a younger man with a camera around his neck, shook his head. "No," he said quietly. "That's not it. He understands. That's the problem." In the jury waiting room, potential jurors sat in uncomfortable chairs and tried not to think about what they'd just witnessed. One older man turned to the woman next to him and said, "I've never seen a child look like that before." She nodded slowly. Neither had she, and neither of them would forget it. The kind of smile that makes you question what you thought you knew about children, about innocence, about age itself. The prosecutor sat in his office on the 3rd floor, the trial materials spread across his desk, and he made a note in the margins of his legal pad. It read, "Not confusion, confidence." He underlined it twice. In his 23 years of prosecution, Marcus had learned to read the difference between a child who was afraid and a child who wasn't. Fear looked like tears, like confusion, like the desperate hope that someone would explain how this had happened. Confidence looked like a smile. Confidence looked like someone who believed, genuinely believed, that the rules of consequence didn't apply to him. The child in that courtroom wasn't broken. He wasn't traumatized or confused or acting out some cry for help. He was, in the most accurate and terrifying sense of the word, in control. And that control was deliberate. Marcus picked up the folder containing the digital evidence and opened it again. The search history, the deleted messages, the timeline. Every piece of it painted the same picture. This wasn't impulsive. This was thought through. The public defender, whose name was Sarah Chen, sat in a small conference room with her client and wondered, not for the first time in her career, if she was on the wrong side of justice. She had taken the assignment because everyone deserved representation. That was the fundamental principle, the assumption of innocence, the right to counsel. She believed in these things. But sitting across from an 11-year-old who showed absolutely no signs of remorse, who treated the legal process like it was a game he was winning, tested something in her that the law school hadn't prepared her for. She had begun her argument focused on his age. That was the standard defense in juvenile cases. The brain isn't developed. The prefrontal cortex isn't fully formed. Children can't be held to adult standards of culpability. But the child across from her looked at her with an expression that suggested he had already dismissed every word she planned to say. He believed he would win, and his confidence was so complete, so unwavering, that for a moment she wondered if he actually would. Judge Harrison sat in his private chambers and did something he had only done twice in 30 years. He called for a full trial. Not a sealed juvenile hearing where the record would disappear and the child's name would be protected and everyone involved would move on quietly. A full trial, open to the public, with a jury, with evidence presented in front of witnesses, with the victim's family present. This decision would later be examined by legal scholars. It would be appealed. It would be written about in law journals. But Harrison knew what the statute allowed, and he knew what the evidence suggested, and he knew something else, something that came from decades on the bench. He knew when a case demanded to be seen, when the public had a right to understand what had happened, when sealed records and protective measures weren't justice, they were erasure. He signed the order and handed it to his clerk. The clerk looked at it and understood immediately why the judge had made this choice. The smile. That's what the order was really about. As families filed back into the courtroom for the afternoon session, the victim's mother sat in that third-row bench and thought about her neighborhood, about the place where she had raised her children, where she had felt safe, where she had believed in the goodness of people, in the basic trust that allowed communities to function. Her town sat about 40 minutes north of the city, the kind of place where street names still meant something, where people knew their neighbors' names and asked about their children and borrowed sugar for weekend baking. The houses had decent yards. The schools were good. The crime rate was low. The kind of place where you could sleep with your windows open in summer without fear. The kind of place where an 11-year-old was still just a child. Or so everyone had believed. That town had a rhythm. Every morning the pattern was the same. Parents woke their children, coffee was made, lunches were packed, cars backed out of driveways in an orderly sequence. Children walked to bus stops or were driven to school. The crossing guard stood at the corner of Maple and Fifth, and Mrs. Hendricks, who had been doing the job for 12 years, waved at every child as they passed. The victim had been part of that rhythm, a fixture, a trusted presence in that community. Not a stranger, but someone woven into the fabric of daily life. Someone whose absence would create a hole that couldn't be filled. Someone whose loss would prove that the safety everyone believed in was an illusion, carefully maintained only as long as nothing happened to shatter it. The morning in question had started like every other morning. The alarm went off at 6. Coffee was brewed. The radio played softly in the kitchen. Windows were open to let in the cool spring air. A routine so ordinary, so predictable, that no one could have known it would be the last one. The victim had moved through the house with the easy familiarity of someone who had lived there for decades, had sat at the kitchen table, had looked out at the neighborhood beginning to wake up, had no idea that somewhere in that same neighborhood a child was preparing for something that would shatter that routine forever. The light was clear and bright. The birds were singing. It was a perfect spring morning. The kind of morning that makes you grateful to be alive. The kind of morning that the victim's family would later wish they could go back to just for one more moment. The smile from the courtroom existed in contrast to that world of routines and trust and the belief that children were safe, that world of coffee and morning light and the simple assumption that today would be like yesterday. The defendant had walked through that same neighborhood. He knew those routines. He knew those patterns. He had access because the community trusted children. Because that's what communities do. They trust. They believe in the fundamental goodness of people, especially young people, and the child had understood something about that trust. He had understood that it could be used against them. The smile in the courtroom was the smile of someone who had learned very early in his life that the rules everyone else followed didn't apply to him, and he was proving it every moment he sat in that chair. A normal morning. That was what the victim had walked into, not knowing it would be the last one. The victim's name was Robert Hayes. He was 53 years old. He had lived in the neighborhood for 18 years, moved there after his divorce, and had built a quiet life on Pinewood Avenue in a small ranch house with a garden that he tended every weekend. He wasn't famous. He wasn't wealthy. He wasn't the kind of person who made headlines or changed the world. He was the kind of person who made neighborhoods better by simply existing in them. He was a retired teacher who now volunteered at the community center teaching photography to kids. He was the man who knew everyone's name, who asked about everyone's problems, who showed up to neighborhood barbecues with homemade potato salad, who remembered that Mrs. Patterson's son was applying to colleges and asked how the applications were going, who noticed when the Johnson's car broke down and offered to give them rides until it was fixed. Robert Hayes was the kind of man that every community needs and rarely appreciates until he's gone. His mornings followed a pattern so consistent that the neighborhood could have set their clocks by it. At 6:15, his bedroom light came on. At 6:30, the kitchen light followed. By 6:45, his coffee was made, always from the same brand, always in the same old ceramic mug with a small chip on the rim that he'd had for 20 years. He would sit at his kitchen table with the newspaper, reading the front page while his son came up. He subscribed to the physical edition, not the online version, because he believed in the ritual. He believed that some things were meant to be done slowly. Some things were meant to be experienced, not just consumed. By 7 o'clock, he was showering. By 7:30, he was dressed. By 8 o'clock, he was out the door, heading to the community center where he volunteered 3 days a week. On the other days, he ran errands, worked in his garden, or visited friends. His life was full, not with drama or excitement, but with the quiet satisfaction of a man who had learned that meaning comes from connection. Robert had become the neighborhood's unofficial grandfather figure, the person young people came to when they had questions about life. He had a way of listening that made you feel heard. He asked follow-up questions. He didn't interrupt with his own stories. He had traveled to 17 countries after his retirement, always solo, always returning with photographs and stories that he shared with genuine enthusiasm. He had learned to cook Thai food from a cookbook and a series of YouTube videos, and he hosted dinners occasionally where he would serve pad Thai and basil chicken and mango sticky rice. He had learned the names of all the birds that came to his feeder and could identify them by their calls. He had started reading Russian literature in his 50s and had favorite authors and passages that he would quote occasionally, always with a slight laugh, as if he found it amusing that he had become the kind of person who quoted Tolstoy. His relationship with the neighborhood children was based on the kind of trust that had been built slowly over years. Parents appreciated that there was an adult they could call on, a man who could keep an eye on their kids if they were running late getting home from work, a man who could be asked to check on the house if they were out of town, a man who actually seemed to enjoy spending time with young people without any agenda. He didn't have children of his own. His marriage had ended childless by mutual decision, and he had made peace with that long ago. but he had found a way to contribute to the lives of other people's children. He would invite them to work in his garden. He would show them how to plant seeds. He would explain the science of why certain flowers bloomed in certain seasons. He had lent his camera to teenagers interested in photography. He had written recommendation letters for college applications. He had been, in every meaningful sense, part of the community's infrastructure of care. The 11-year-old defendant had known Robert Hayes for his entire life. Robert had been present at neighborhood events since the child was a toddler. The child had played in his yard. Robert had taught him the names of plants, had shown him how to take photographs, had been kind to him in the way that Robert was kind to everyone. There was no dramatic conflict between them, no abuse, no trauma, no story that would explain what was coming. Just an adult who was generous with his time and a child who had lived in a neighborhood where such generosity was expected and normal. Which made it all worse in a way that people struggled to articulate. There was no reason, no justification hiding in a story of neglect or cruelty. Just a child who had decided, for reasons that would take a team of psychologists months to try to understand, that he wanted to hurt someone, and he had chosen the person who had been kind to him. On the morning of that perfect spring day, Robert had followed his routine exactly. Coffee at 6:45, newspaper at 7. The morning news playing quietly on the small radio in his kitchen. He had planned to work in his garden that afternoon. The tulips were beginning to fade, and he wanted to pull them and plant the summer annuals. He had spent 20 minutes the night before looking at seed catalogs, marking which flowers he wanted to try this year. Zinnias, cosmos, sweet peas climbing up the trellis. He had made a list. He had texted a friend to see if he wanted to help, and they had plans to work together the following Saturday. Everything was mapped out. Everything was in order. His garden was going to be beautiful. His life was continuing on its quiet trajectory of meaning and connection. He left his house at 8 o'clock, heading to the community center for his volunteer shift. He stopped at the corner to chat with Mrs. Hendricks, the crossing guard, about the weather. He asked about her granddaughter's soccer team. He was kind and present and fully alive in that moment. He drove to the community center through streets lined with trees just beginning to leaf out. He parked in his usual spot. He gathered his camera equipment from the passenger seat. He locked his car. He walked into the building. And that was the last moment anyone saw him alive. The last moment before a child who had been taught kindness decided to reject it entirely. The last ordinary afternoon before a neighborhood discovered that safety was conditional, that trust could be weaponized, that the people we believe are safest can be taken from us by someone small enough to fit in a classroom. The silence that followed felt wrong because it was. It was the silence of a neighborhood realizing that something fundamental had broken. That the world they had believed in, the world where children were innocent and communities were safe and good people like Robert Hayes lived long, full lives, wasn't real. Or it was real, but fragile, breakable, subject to the whims of a child who had decided on one perfect spring afternoon that he wanted to know what it felt like to hurt someone. And he had stolen that answer from a man who had never done anything but help him. The afternoon light was the kind that photographers dream about. Golden, diffused, warm without being harsh, the kind of light that makes ordinary things look beautiful. At 2 o'clock, the neighborhood was quiet in the way that spring afternoons are quiet. Most of the adults were at work. Most of the children were still in school. The streets were empty except for the occasional dog walker or someone running errands. The trees were that pale green of new growth, not quite full yet, so the light could still filter through the branches and create dappled patterns on the sidewalk. A breeze moved through, carrying the smell of fresh earth from gardens being turned over. Somewhere, a lawnmower started up. Somewhere else, a child called out to a friend. The neighborhood was alive with the ordinary sounds of a weekday afternoon. Nothing suggested that anything unusual was happening. Nothing warned that this was the moment everything was about to change. Robert had returned home at 1:30. His volunteer shift had ended, and he had stopped at the grocery store to pick up flowers for his garden. Petunias, impatiens, a hanging basket of ivy geranium. He had carried them inside, set them on the porch in their plastic containers, and then changed out of his volunteer shirt into old shorts and a work shirt he kept for yard work. He had made a sandwich, turkey and Swiss on whole wheat with mustard, and eaten it standing at the kitchen counter while reading the weather forecast. The forecast predicted sunny skies for the next 5 days. Perfect conditions for planting. He had checked his garden one more time, mentally organizing the order in which he would work. First, pull the old tulips, then prepare the soil, then plant the annuals in the pattern he had sketched out on a piece of graph paper the night before. He had grabbed his work gloves from the cabinet by the back door. He had filled his watering can. Everything was preparation. Everything was anticipation. Everything was normal. The 11-year-old had left school at 3 o'clock, like every other day. He had walked home through the same streets, past the same houses, following the same route. His backpack contained his homework. His lunchbox contained the remains of his sandwich. His mind contained a plan that had been forming for weeks, not consciously articulated, not written down anywhere, but present, a shape, an intention, a decision that had somehow calcified in whatever space exists before conscience fully forms. He had walked past the crossing guard. He had walked past the park. He had walked past the houses of people who knew his name. He had reached his own street at 3:15. But he had not gone to his house. He had turned instead toward Robert's place. His feet had carried him there the way feet carry us toward decisions we've already made, even if we haven't admitted them to ourselves. Robert was in the backyard. He was kneeling in the dirt, his hands already soil-stained, working on the front corner of the flower bed. He had pulled 6 of the old tulips and was in the process of loosening the soil when he heard the gate open. He turned and saw the child. His face brightened the way it did when he saw any neighborhood kid. He said something like, "Hey there, perfect timing. Want to help me plant these flowers?" The child had nodded. They had talked for a moment about nothing important, about school, about the weather, about whether the child wanted to try using the camera again. Robert had been completely unaware, completely trusting, completely vulnerable. He had not seen the calculation in the child's eyes because he was not looking for it. Why would he? This was a child he had known since birth, a child he had helped teach, a child he had shown kindness to consistently, without expectation of anything in return. The security camera mounted on the corner of Robert's house, installed years ago after a minor break-in 3 blocks away, captured it all without judgment or emotion. The timestamp read 3:22 p.m. The footage showed Robert still kneeling, the child standing nearby. It showed the moment Robert turned away to reach for the watering can. It showed the child moving. It captured the moment without sound. That was the cruelest part of the footage, in a way, that it was silent, that viewers would later watch it with the audio turned up all the way, desperate to hear something, anything that would make sense of what they were seeing. But there were no screams, no shouts, no sounds of struggle, just movement. Just a child and an adult in a garden, captured by a camera that never blinked, never looked away, never missed a single moment of what happened next. The neighborhood continued around them, unaware. Mrs. Patterson was on her porch watering plants. She was facing the other direction, toward her own yard, toward the street. The sound of the lawnmower continued 2 streets over. Someone's dog barked. A car passed on the main road 3 blocks away. The world was proceeding with its ordinary business, completely indifferent to the fact that in one specific garden, on one specific afternoon, something was being stolen. Not just a life, but the sense of safety that a neighborhood had relied on. The belief that communities looked out for each other. The assumption that kindness was safe. That the people you helped would help you in return. That children were innocent. The camera continued recording. The timestamp advanced. 3:23, 3:24. Robert's hands fell still. The child stood for a moment, then turned and walked away. Just walked. Calmly. No running. No panic. He left through the gate, moving back toward the street with the same pace he used every day, walking to school. He did not look back. He did not check to see if anyone had noticed. He simply walked, and the neighborhood accepted him as it always had, as just another child moving through a familiar space. The camera kept running. The timestamp continued. 3:25. The light was still golden. The breeze was still warm. The neighborhood was still quiet. Nothing had changed, and everything had changed. Everything would never be the same again. The call came at 4:15. A woman's voice, panicked, barely coherent, saying that she had stopped by to check on Robert because he hadn't answered his phone. She had used the spare key he had given her months ago for emergencies. She had opened the back door. She had called his name. And then she had found him. The dispatcher remained calm, asking questions that the woman could barely answer. Was he breathing? Was he conscious? Was there any sign of injury? The woman kept saying, I don't know. He's just lying there. He's just lying there. The police arrived in 4 minutes. The paramedics arrived in 5. By 4:30, the backyard of the house on Pinewood Avenue had been transformed from a place of gardening into a crime scene. The first responders who entered that space would later be interviewed about what they observed. They would be asked specific questions by detectives. They would write reports. They would testify in court. But what none of them could fully convey, no matter how many words they used, was the feeling of that moment, the feeling of entering a space where violence had occurred, the feeling of seeing a person you couldn't help, the feeling of understanding immediately and without doubt that this was a homicide. One officer would later describe it as a wrongness in the room. Another would say, you know immediately, You know before you know why. Your body understands before your mind catches up. The garden that Robert had been planning and anticipating working on for weeks was now a crime scene. The flowers he had bought that morning remained in their plastic containers on the porch. The watering can lay on its side. The soil was disturbed, and in the center of it all, Robert lay motionless. What struck the investigators immediately was the absence of struggle. There were no defensive wounds, no signs of a fight, no indication that Robert had attempted to escape or resist. The scene was quiet in a way that scenes of violence usually aren't. There was no chaos, no overturned furniture or scattered objects. Just an old man lying in his garden in the middle of the afternoon, surrounded by the flowers he would never plant. One detective, a woman named Sarah Kowalski, who had worked homicides for 12 years, knelt down and observed the positioning of the body. The placement seemed deliberate, arranged, almost. Not the way a body naturally falls when someone collapses. The paramedics exchanged glances and made the call. There was nothing they could do here. This was now a police matter. This was now a death investigation. The medical examiner arrived at 5 o'clock. She was a precise woman named Dr. Patricia Okonkwo, who approached every body with the same clinical attention to detail. She began her observations before the body was moved. She noted the condition. She noted the positioning. She noted the absence of struggle. She noted something else, too, something that would later be crucial. She noted that whoever had done this had done so without panic, without rushing. The scene suggested intentionality. The scene suggested someone who was not afraid of being discovered. The scene suggested someone who had thought through the sequence of events and then executed it with calculation. There was no sign of rage, no sign of crime of passion, just cold action. Just a child who had decided to hurt someone and then had done so in a manner that suggested he had thought about how. The detective in charge was a man named Michael Torres, who had been investigating crimes in this suburban area for 15 years. He stood in the backyard and felt something shift in his understanding of his job. He had investigated burglaries and assaults and robberies. He had investigated crimes born of anger or desperation born of anger. But this was different. This was a child. An 11-year-old child who had walked through this neighborhood that afternoon and who had made a choice that would echo through this community for decades. Torres turned to his partner and said quietly, "This is planned." His partner nodded. Both of them were thinking the same thing. The preliminary investigation was going to expand rapidly, because a child didn't commit a crime like this without leaving evidence. Digital evidence, physical evidence, behavioral evidence. The child had made a mistake somewhere. They all did. Torres was going to find it. The forensic team arrived at 5:30. They began photographing everything: the garden, the body, the surrounding area, the porch with the flowers, the watering can, the work gloves still on Robert's hands, now stained with dirt and something else. Every photograph was taken from multiple angles. Every measurement was recorded. Every detail that might seem insignificant was documented. The team worked methodically, knowing that nothing could be assumed, nothing could be missed. The scene was processed with the kind of attention that homicide scenes received, the kind of attention that told everyone present that this death was being treated as a serious matter. This was not going to be overlooked. This was not going to be forgotten. As evening fell and the temperature dropped, the neighborhood began to understand that something terrible had happened. Police cars lined the street. Yellow crime scene tape cordoned off Robert's property. Officers stood at various points, managing the growing crowd of neighbors who had come outside to see what was happening. Parents pulled their children inside. Questions were asked. Information was scarce. But everyone understood. Robert Hayes wasn't coming home. The man who had been kind to their children. The man who had known their names, the man who had planted flowers and taken photographs and lived a quiet life full of meaning. He was gone. And he was gone because of someone they all knew, someone young, someone small, someone who walked these same streets they walked and attended the same schools and seemed in every visible way like a normal child. The crime scene would eventually be released. The flowers on the porch would be cleaned up. The area would be washed down. The garden that Robert had planned so carefully would eventually be tended by someone else. But nothing would ever be quite the same in that garden. Nothing would ever feel quite as safe, because the scene had revealed something that communities don't like to acknowledge, that violence doesn't always come from outside, that it doesn't always come from strangers, that it can come from within, that it can come from the children you've known their whole lives, that the people you trust can be hurt by the people you've helped raise. The camera had captured the moment without judgment. The scene had been processed with precision, and the investigation had begun in earnest. This wasn't an accident. This was a crime, and the person responsible was walking free through the neighborhood, still attending school, still smiling, still utterly convinced that the rules didn't apply to him. By evening, Detective Torres had made the decision to interview every child in the neighborhood who had been home that afternoon. It was standard procedure. Cast the net wide. Look for witnesses. But he had something else in mind, too. He wanted to observe how children responded to questions. He wanted to see who was nervous, who was shocked, who was lying. The 11-year-old defendant was brought into the police station at 6 o'clock with his mother, a woman named Linda who worked as an accountant and who was struggling to understand why her son was being questioned about something that had happened to their neighbor. She believed her son. She had no reason not to believe her son. Children didn't commit crimes like this. Children his age weren't capable of the kind of planning and execution that this crime suggested. She sat next to her son in the interview room, a small space with white walls and a table and a digital recorder that was turned on at the beginning of the session. Torres sat across from them with his notepad. He was calm, professional, kind even. He wasn't accusatory. He was simply asking questions. "So you were home this afternoon?" The child nodded. "What time did you get home from school?" The child answered immediately. "About 3:15. Torres made a note. That part was true. The school bus records confirmed it. "And what did you do when you got home?" This was where it started. The child's story was smooth. Almost too smooth, like it had been rehearsed, like it had been prepared in advance. He said he had gone straight inside. He said his mom wasn't home yet. She didn't get home until 5 o'clock. He said he had made a snack. He said he had done his homework. He said he had played video games. He said he had watched television. He said he hadn't left the house. The story was complete. It was detailed. It was also, Torres was beginning to understand, completely fabricated. Torres didn't push, he didn't accuse, he simply asked follow-up questions. What snack had he made? What was the exact name of the video game? What show had he been watching? With each question, the child's story remained consistent, but Torres noticed something that made his skin prickle. The phrases didn't sound natural. When the child talked about making a snack, he said something like, "I prepared a nutritious afternoon snack consisting of grapes and whole wheat crackers." No 11-year-old talked like that. No child would use the word consisting. When asked about the video game, the child repeated back the exact name that Torres had mentioned, as if he had been waiting for the specific term to anchor his story. The level of rehearsal was evident if you knew what to look for. And Torres knew what to look for. The child's mother, sitting next to him, was beginning to sense that something was wrong. She kept glancing at her son, as if she expected him to suddenly change his story, as if at any moment he would admit that he had done something small and fixable. But he didn't. He maintained the calm, the composure, the rehearsed quality of his responses. At one point, Torres asked, "Did you see Mr. Hayes at all today?" The child said, "No." But there was a microsecond of hesitation, so brief that his mother didn't notice. But Torres noticed. In that microsecond, Torres saw the child process the question, consider his options, and then deliver the prepared answer. The child knew the question was coming, or at least he had prepared for the possibility that it might. Torres made a note of the hesitation. He made a note of the timing. He made a note of the fact that a child who hadn't been told Robert was dead was very carefully explaining why he couldn't have seen him that day. At 5:15, Torres said, "Mr. Hayes was found at approximately 4:15. Before that time, between 3:30 and 4:15, can you account for your whereabouts?" The child repeated his story. At home, doing homework, playing video games. His mother put her hand on his arm, as if offering support, but also, Torres thought, as if she was trying to hold him in place. As if she was afraid that if she let go, he might float away and reveal something neither of them was ready to acknowledge. Torres continued with his questions, each one designed to probe the story from different angles. He asked about what his homework had been. The child answered. He asked about which video game. The child answered. He asked what his mother usually made for dinner on Tuesdays. The child answered. Every answer was correct. Every answer was prepared. Every answer was designed to create the illusion of a normal afternoon at home. The forensic team, working simultaneously, was beginning to find inconsistencies of a different kind. They had pulled footage from 2 additional security cameras in the neighborhood, one on a corner house, one on a street light. The footage showed the child's route home from school. It showed him arriving at his house at 3:15, as he claimed. But the next footage, from a camera positioned at the edge of Robert's property, showed the child leaving Robert's yard at 3:28 and walking back toward his own house at 3:32. The timestamps were precise. The movement was clear. The child had not been home doing homework. The child had been at Robert's house, and he had left approximately 6 minutes before the woman who discovered the body arrived. Torres didn't reveal this information during the interview. He simply continued asking questions. He was building a record of lies, a documented pattern of deception, because when he eventually confronted the child with the footage, he wanted every lie to be on record. He wanted to establish that the child understood the difference between truth and falsehood, that the child was capable of deliberate deception, that the child was not confused or panicked or acting without understanding. The child was lying methodically. The child was protecting himself with calculated precision. And that fact, that a child this young could maintain a false story with such composure, told Torres something important. Someone had practiced this story. Someone had prepared for this interview. Someone had thought through the questions and prepared the answers. The only question was whether that someone was the child himself or if there was an adult involved. Torres looked at the mother, who was still sitting beside her son with increasing distress on her face. He made a note. He would be looking into her movements that afternoon as well. The warrant was signed at 7 p.m. on the same day as the discovery. Detective Torres had applied for it immediately after the interview with the child, armed with the security footage and the inconsistencies in the child's statement. The warrant covered the child's phone, his laptop, and any other digital devices in the home. By 8 o'clock, forensic technicians were examining the devices in a secure facility, and what they began to uncover painted a picture so clear that it would later be difficult for anyone to deny. The phone was the most revealing. Unlike an adult who might understand how to delete evidence thoroughly, the child had deleted messages, yes, but the deletion wasn't complete. The forensic tools available to law enforcement could recover deleted data, and the data they recovered told a story that the child's mouth never would. In the 3 months preceding Robert's death, the child's search history had been marked by a specific pattern. At first, the searches were vague. How do people hurt each other? What happens when someone is badly hurt? Can a person be hurt without a weapon? The searches gradually became more specific. How to hurt someone and not get caught. Why do people kill? What evidence gets left at a crime scene? How do police investigate? By the final month, the searches had narrowed to something almost surgical in their precision. They were looking at Robert specifically. Photos of Robert from the neighborhood social media groups. Information about his schedule, his routine, his patterns. The child had been planning, not impulsively, not as some kind of abstract thought experiment. He had been researching. He had been preparing. He had been thinking through the logistics of committing a crime against a specific person. The deleted messages were equally damning. Text conversations between the child and another neighborhood boy, recovered through forensic tools, showed a sequence of increasingly concerning exchanges. The messages started with vague discussions about violence and consequence, but as the months progressed, they became targeted. "I know how I would do it," one message read. Another said, "I would make it look like an accident." A third message, dated 2 weeks before the murder, stated plainly, "I'm going to do it." The other boy had not taken it seriously. He had responded with the kind of skepticism that comes from genuine disbelief. But the child's next message was simple. "Watch, I will prove it." The forensic team documented every message, every timestamp, every detail. The digital trail was undeniable. It was comprehensive. It was damning. The laptop revealed additional searches. The child had accessed websites about psychology. websites about criminal procedure, websites about how murders were investigated. One search history showed the child looking at articles about juvenile justice, specifically about the sentences given to children who committed violent crimes. He had read about cases. He had studied precedent. He had looked at the legal framework that he would be operating within. This was not a child acting on impulse. This was not a child overwhelmed by emotion or acting out of desperation. This was a child conducting research. This was a child preparing. This was a child who had thought about the legal consequences and had decided they were acceptable. Or more accurately, had decided they didn't apply to him. The forensic technician made a note in her report. The defendant's digital activity demonstrates planning, intent, and awareness of legal consequences. The timestamp on the device data correlated perfectly with the security footage. At 3:22 p.m. on the afternoon in question, the child's phone had connected to Robert's home Wi-Fi network, a connection that had not been in place before that date. A connection that would have required the child to be present at Robert's house. The phone had remained connected for 6 minutes and 14 seconds, the exact duration shown in the security footage. The child's location data, which had been enabled in his phone's settings, showed his precise position at Robert's house during that window. There was no ambiguity. There was no room for alternate explanation. The digital evidence, combined with the physical evidence and the security footage, created a narrative so complete that there was almost nothing left to dispute. The prosecutor, Marcus, sat in his office and read through the forensic report with a sense of relief that bordered on something darker. Relief because the evidence was so strong that it would withstand any defense. Relief because a case that could have been complicated by questions about juvenile culpability now had the kind of documentation that made those questions almost irrelevant. The child had demonstrated understanding. The child had demonstrated planning. The child had demonstrated awareness of consequences. The child had demonstrated through his digital footprint that he had thought through what he was about to do and had done it anyway. When the trial began, the prosecutor would have something that was almost impossible to defend against: the defendant's own documented intent. Marcus picked up his phone and called Detective Torres. "It's airtight," he said. Torres, listening from his car, where he was still conducting neighborhood interviews, felt something settle in his chest. "We have what we need?" Torres asked. "We have more than what we need," Marcus replied. "We have everything: digital timeline, search history, messages where he told someone he was going to do this, security footage that places him at the scene at the exact moment, his phone data, his location data, his explicit statements of intent." Torres was quiet for a moment. "What about the age thing?" he asked. "The judge is going to look at the evidence and the planning and the explicit awareness of consequences," Marcus said. "And the judge is going to understand that this isn't a case that gets dismissed because of age. This is a case where age becomes almost irrelevant." The child, meanwhile, was sitting in his home, still under his mother's supervision, still maintaining his calm exterior, still convinced that the rules didn't apply to him. He didn't know that his phone had been seized. He didn't know that his searches had been recovered. He didn't know that his deleted messages were no longer deleted. He didn't know that his location data had placed him at the crime scene with a precision that made denying it impossible. He didn't know that the digital footprint he had left, the trail of his own curiosity, his own planning, his own documented intent, was mounting a case against him that would be almost impossible to escape. He believed he had been careful. He believed he had covered his tracks. He believed the story he had told the detective would hold up. But digital evidence doesn't lie. Digital evidence doesn't forget. Digital evidence doesn't care about age or psychology or the legal protections available to children. It simply exists. A perfect record of intention and action and decision. Truth stacking up with every recovered file and every timestamp and every documented search. The system was beginning to move, and it was moving toward a conclusion that the child had not anticipated. The psychological evaluation was ordered by the court at the request of the prosecutor. Marcus wanted to establish that the child was not acting from a place of diminished capacity. He wanted to establish that the child understood what he was doing, that the child was capable of forming intent. That age, while a factor, could not be used as a blanket protection for someone who had demonstrated this level of deliberate planning. The psychologist assigned to the case was Dr. James Mitchell, a man in his 60s who had evaluated hundreds of defendants over his career. He had seen trauma, he had seen abuse, he had seen legitimate mental illness and developmental delay. But he had also seen something else. Children who were, in the most accurate and difficult sense of the term, dangerous. Children whose minds worked in ways that deviated significantly from typical development, not because of trauma or illness, but because of something more fundamental. A difference in how they processed empathy, a difference in how they understood consequence, a difference in how they related to other human beings. Mitchell spent 8 hours with the child across 4 separate sessions. He conducted interviews. He administered psychological tests. He observed behavior. He took extensive notes. And what he documented in his report would later be presented in court as evidence of both culpability and concern. The child, according to Mitchell's evaluation, demonstrated several consistent traits. First was a remarkable lack of empathy. When asked how he imagined the victim's family felt, the child responded matter-of-factly, as if discussing an abstract concept rather than the grief of actual people. "They're sad, I guess," he said. When pressed, he added, "But they'll get over it. People always do." There was no recognition that some griefs don't get gotten over. Some losses are permanent. Some pain echoes forward for decades. The child understood the words, but not the meaning. He could articulate that people felt sad, but he couldn't access the emotional reality of that sadness. The second trait Mitchell noted was what he described as grandiosity. The child's sense of his own importance was disproportionate to reality. He spoke about his planning as if it were a sophisticated accomplishment. He seemed to view the investigation as something he was winning. When Mitchell asked him directly about his smile in the courtroom, the child's response was revealing. "I wanted them to know that I'm smarter than they are," he said. "I wanted them to know that I could do something they couldn't stop. I wanted them to see that I'm not like other kids." The narcissism was evident. The child didn't view himself as someone who had caused harm. He viewed himself as someone who had demonstrated his superiority. The victim wasn't a person whose life had been stolen. The victim was a prop in a narrative about how smart and special the child was. The third trait was manipulation. Mitchell described it as the child's ability to craft narratives that served his interests. The false story told to the detective. The carefully maintained composure during interviews. The strategic use of emotion, or in this case, the strategic absence of emotion. The child had learned that crying sometimes helped in getting what he wanted, but he also understood that in some contexts, refusing to cry was more powerful. The smile in the courtroom was the same calculation. The child had assessed the audience and had decided that demonstrating confidence and invulnerability would be more effective than expressing remorse or confusion. He was reading the room and performing. He was doing what worked. Mitchell made a note. The defendant demonstrates sophisticated understanding of social dynamics and manipulates those dynamics to serve his interests. The fourth trait was what Mitchell labeled as callousness, not anger, not rage, just a fundamental lack of emotional connection to the impact of his actions. When shown photographs of the crime scene, the child's response was clinical. When told about Robert's background, the volunteer work, the kindness, the quiet life, the child said nothing. When confronted with the grief of Robert's family, the child remained unmoved. There was no moment of recognition, no moment where something inside him seemed to register the magnitude of what he had done. It was as if the child was observing the world through glass. He could see it. He could understand it intellectually. But he couldn't feel it. And without feeling, without that fundamental human capacity for empathy and regret, there was nothing to restrain his actions. Mitchell spent considerable time in his evaluation discussing what these traits suggested about the child's future. Was the child dangerous? Yes, Mitchell wrote. Not in the way that an angry or traumatized child might be dangerous, acting out of pain or confusion, but in a more fundamental way. The child appeared to have a neurological or developmental difference that meant he processed empathy differently than most people. He was capable of planning. He was capable of executing. He was capable of lying convincingly. He was capable of maintaining composure under pressure, but he seemed to lack the internal moral compass that kept most people from acting on harmful impulses. Most children, when they thought about hurting someone, felt something that stopped them. Fear, guilt, empathy, remorse. Something in their emotional system said no. The child in question appeared not to have that mechanism, or if he had it, it wasn't functioning. When Judge Harrison read Mitchell's report, he read it twice. Once quickly, to understand the general conclusions. A second time slowly, to absorb the specific language and the data supporting it. The report was professionally written and carefully qualified. Mitchell was clear that he was not diagnosing a specific disorder. He was not claiming certainty about the child's future. He was simply documenting what he observed, a child who lacked certain normal emotional responses, a child who understood the world intellectually but not emotionally, a child who was capable of harm without the usual internal restraints that kept people from causing harm. The judge closed the report and set it on his desk and thought about what it meant. It meant that the defense's argument that the child was too young to be held accountable would have to contend with evidence that the child had thought through his actions carefully. The smile wasn't innocence. It wasn't confusion. It wasn't the smile of a child who didn't understand consequence. It was the smile of a child who understood consequence completely and had decided it didn't apply to him. It was the smile of someone performing control. And that performance, Harrison understood, was exactly what the evidence suggested. The smile was strategy. The trial began on a Monday in May, 3 months after Robert's death. The courtroom was packed. The media had picked up the story. An 11-year-old accused of murder was unusual enough to warrant attention. The local news had covered it extensively. National outlets had begun following it as well. The question of whether a child so young could be held fully accountable for such a crime was the kind of legal and moral question that people had opinions about. The public was watching, and the defendant entering the courtroom that first morning in a suit his mother had bought him, gray, fitted, expensive-looking, seemed to understand that he was the center of attention. He seemed to understand that this was his moment, his stage, his audience. He walked through the doors with his chin slightly elevated. He looked toward the cameras in the hallway with what could only be described as satisfaction. The prosecutor's face tightened as he watched the defendant's demeanor. This was not the composure of a child. This was not the nervous energy of someone facing serious charges. This was someone who was performing, someone who had rehearsed this moment, someone who believed he was winning. Marcus had seen it before in adult defendants, the kind of person who believed the legal system was a game they could win through the right combination of presentation and manipulation. But seeing it in an 11-year-old was different. It was darker. It suggested something about the child that went beyond age. It suggested someone who had internalized the idea that he was above the normal rules, that consequences were something that happened to other people, that this courtroom, with all its authority and tradition, was ultimately just another audience to perform for. The judge entered, and everyone stood. Judge Harrison moved with the kind of deliberation that suggested he was aware of every moment's significance. He had decided to allow this trial to be public, which meant the weight of that decision rested on him. The case would be discussed. It would be analyzed. It would potentially set precedent for how young children who committed serious crimes would be handled. The judge sat and surveyed the courtroom, the packed gallery, the press, the family members, the defendant sitting at the defense table with his attorney, Sarah Chen, who looked as if she had slept poorly. The judge's gaze settled on the defendant for a moment. The child did not look away. The child met the judge's gaze directly, and something in that moment seemed to pass between them. An understanding, a recognition that this was going to be different than the child expected. The prosecution's opening statement laid out the case methodically. Marcus spoke about the victim, not as a tragedy, but as a person. Robert Hayes, 53 years old, a man who had lived quietly and kindly in a community that trusted him, a man who had been vulnerable not because he was weak, but because he trusted the world to be fundamentally good. The prosecution painted the defendant not as a child overwhelmed by circumstance, but as someone who had made deliberate choices. Marcus described the search history, the deleted messages, the planning, the security footage, the digital footprint that proved the defendant had been at the crime scene at the exact moment of the crime. He described a psychological evaluation that suggested the defendant lacked certain normal emotional responses. He did this all calmly, without histrionics, letting the facts speak for themselves. The defense's opening statement took a different approach. Sarah Chen argued that her client's age was central to understanding what had happened, that children's brains weren't fully developed, that impulsivity and poor judgment were hallmarks of childhood, that the charges being brought reflected a fundamental misunderstanding of child development, that the evidence, while seeming clear, had to be interpreted through the lens of a child's limitations. But even as she spoke these things, even as she made the legal arguments that were expected of her, she was aware that the defendant sitting next to her was undermining every word, because the child was smiling. Not obviously, not in a way that would cause the judge to immediately shut it down, but a slight curve to his mouth, a glimmer in his eyes that suggested he was enjoying this, that he was finding it entertaining, that he believed his attorney's arguments were going to work because he believed the rules didn't apply to him. The first week of testimony focused on the forensic evidence. The security footage was played for the jury. The room went silent as they watched. The prosecution did not narrate what they were seeing. They simply let the footage speak. A child entering a frame, an adult unaware, movement, and then the child leaving. The jury watched it in complete silence. One juror, a woman in her 50s, closed her eyes partway through. Another juror, a man in his 30s, leaned forward. The judge watched the defendant's face as the jury watched the footage. The defendant's smile remained. Throughout the week, as testimony continued about the physical evidence and the digital evidence and the timeline that corroborated everything, the defendant maintained his composure. During breaks, he would laugh with his attorney. He would look at the gallery. He would scan the courtroom as if he were assessing his performance. The victim's family sat in the gallery every day. Patricia, the woman who had discovered the body, sat in the same seat in the third row. Next to her was her sister. Next to her was her ex-husband. And next to him, their son, the boy 3 years older than the defendant. Every time the defendant smiled, Patricia's sister would put her hand on Patricia's arm, as if trying to hold her in place, trying to keep her from standing up and speaking the words that were clearly forming behind her eyes. The courtroom was a stage, and the defendant understood that. He understood that every smile was being observed. Every moment of composure was being noted. He understood that he was the center of attention, and he was performing. The judge understood this too. Harrison understood that this case was no longer just about what the child had done. It was about who the child was. And who the child was seemed to be someone who felt no fear. Someone who believed that the system, the judge, the jury, the lawyers, the evidence, was ultimately just an audience, and audiences could be managed. The second week of trial was dedicated to what the prosecution called the evidence presentation. But it was more than that. It was a systematic dismantling of every possible defense the child might construct. It was truth, organized and presented methodically, in a way that allowed no escape. The prosecution began with the security footage again, but this time they played it multiple times, from multiple angles, in slow motion, in real time, with timestamps clearly visible on the screen. They played it without commentary. They let the jury watch. They let the jury absorb. And they let the jury begin to understand that what they were watching was not ambiguous. It was not subject to interpretation. It was a child moving through space at a specific moment, doing something that could no longer be denied or explained away. The digital forensic expert, a woman named Dr. Helen Park, took the stand and walked the jury through the recovered data with the precision of someone who had testified in hundreds of cases. She explained how deleted messages could be recovered. She explained how location data worked. She explained how the timeline correlated. She showed the jury the search history on a screen large enough that everyone in the courtroom could read the defendant's own words. How to hurt someone and not get caught. That phrase appeared on the screen and jurors' jaws tightened. Why do people kill? That phrase appeared next. The jury was reading the defendant's own curiosity, his own research, his own documented planning. Dr. Park's testimony was clinical. She didn't add editorials. She didn't express outrage. She simply presented information. But the information spoke for itself. The timestamp correlations were presented next. The security footage showed the child at Robert's house at 3:22 p.m. The child's phone connected to Robert's Wi-Fi at 3:22 p.m. The location data placed the child at those coordinates at 3:22 p.m. The deleted messages referenced the act the child intended to commit. The search history showed months of planning leading up to the afternoon in question. Every piece of evidence aligned. Every timestamp matched. Every digital fingerprint confirmed the narrative that the prosecution was building. There were no contradictions. There were no gaps. There was no room for reasonable doubt. The prosecution was not presenting a circumstantial case. They were presenting a case built on the defendant's own digital footprint, his own documented intent, his own recorded location at the moment the crime occurred. When the physical evidence was presented, the courtroom grew even more silent. A forensic pathologist explained the findings with appropriate restraint, using language that conveyed the facts without unnecessary graphic detail. The injuries were consistent with deliberate action. The positioning of the body was consistent with the security footage timeline. There were no signs of struggle because there had been no struggle. Robert had been unaware. Robert had been vulnerable. Robert had been killed by someone he trusted. The pathologist's conclusion was clear. The death was a homicide, and it was consistent with the defendant's documented planning and the timeline established by the security footage. At one point during Dr. Park's testimony, when she was displaying the deleted message that read, "I'm going to do it," the defendant's smile finally faltered. It wasn't obvious. It wasn't dramatic. But it happened. For the first time in the trial, something in the child's composure shifted. Something in the certainty cracked. The message was his message. The intent was his intent. The action was his action. And it was all documented, all proven, all undeniable. Sarah Chen, watching her client's face, saw it too. She saw the moment when the child began to understand that the performance wasn't working, that the evidence didn't care about his smile, that the jury wasn't looking at his composure. They were looking at facts, at timelines, at his own documented words and actions and location. The jury foreman, a man named James, watched the defendant's face during the testimony. He was looking for signs of remorse, signs of understanding, signs that the child grasped the magnitude of what had been done. What he saw instead was a child who had begun to realize that his control was slipping, that the performance was ending. that the system, which he had believed to be something he could manipulate, was operating according to rules that had nothing to do with age or composure, or whether or not he could maintain a smile. The system operated according to evidence, and the evidence was overwhelming. James made a mental note. He would remember this moment. He would remember the instant when the child's certainty collapsed. By the end of the week, the prosecution had presented every piece of evidence. The security footage from multiple angles, the digital forensic data, the location tracking, the deleted messages, the search history, the timeline that matched perfectly with every piece of corroborating evidence, the psychological evaluation showing the child's lack of empathy and his grandiosity and his understanding of consequence, the physical evidence from the crime scene, the pathologist's findings, everything. By Friday afternoon, when Marcus rested his case, there was nothing left to present. There was no ambiguity. There was no reasonable doubt. There was only the overwhelming, undeniable reality that the child sitting in that courtroom had planned a crime, had executed it, and had then tried to lie about it when confronted with evidence. The courtroom felt different as the weekend approached. The tension that had existed at the beginning of the trial had shifted. The energy had moved from curiosity to certainty. The jury had seen the evidence. The jury had heard the testimony. The jury understood what had happened. And the defendant, sitting at the defense table in his expensive suit, had finally understood that his smile wasn't going to save him, that his performance wasn't going to work, that the system, despite his belief in his own specialness and superiority, was going to operate according to truth. The smile was gone now. In its place was something closer to confusion, as if the child was genuinely struggling to understand how the rules, which he had been so certain didn't apply to him, were suddenly, undeniably, applying to him. The room exhaled, and everyone in it knew that the outcome was no longer in doubt. The defense's case was brief. Sarah Chen called a child psychologist to testify about brain development. She called a teacher who described the defendant as a quiet, well-behaved student. She presented character witnesses who painted a picture of a normal child in a normal family. But the testimony felt hollow now. The evidence had already been presented. The jury had already heard the truth. The defense was going through motions because that's what the legal system required, but everyone in the courtroom understood that the verdict was already decided. What remained was the cross-examination, the prosecution's opportunity to confront the defendant directly, to ask him questions, to give him a chance to explain himself, to see finally if the mask would hold or if it would crack. Marcus approached the task carefully. He wasn't going to be aggressive. He wasn't going to yell or accuse. He was simply going to ask questions and listen to the answers. The defendant took the stand, wearing the same suit he had worn throughout the trial. He was composed. He was calm. He was ready. Or at least, he believed he was ready. Marcus began with easy questions. "What is your name?" the defendant answered. "How old are you?" the defendant answered. "Do you understand the importance of telling the truth in this courtroom?" The defendant nodded and said yes. The foundation was being laid. The prosecutor was establishing that the child understood the concept of truthfulness, understood the importance of it, understood that lying under oath was a serious matter. Marcus was building the framework that would make the defendant's later contradictions undeniable. Then Marcus began asking about the afternoon in question. The defendant began telling his story again, the story he had told the detective, the story he had maintained throughout the investigation, the story that had been contradicted by every piece of physical and digital evidence. He was home, he said. He had come home from school. He had done his homework. He had made a snack. He had played video games. He had not left the house. The story was smooth. The delivery was calm. The defendant was performing. Marcus listened without interrupting. He let the story be fully told, and then he began asking follow-up questions. "What video game were you playing?" Marcus asked. The defendant answered with a specific game title. "For how long did you play this game?" The defendant answered. "What level were you on when you finished?" The defendant answered. The questions were specific. The answers were detailed. The defendant was prepared. He had thought through the story. He had details ready. But then Marcus asked something that seemed innocuous. "In the time between when you got home at 3:15 and when your mother got home at 5 o'clock, did you look out any windows?" The defendant hesitated. It was barely perceptible, but it was there. A hesitation, a moment where the automatic response didn't come. The defendant said no, he had not looked out any windows. He had been focused on his games. Marcus nodded. He walked to the evidence table and picked up a photograph. It was a still from the security footage. It showed the defendant at Robert's house. Marcus showed the photograph to the defendant and asked, "Do you recognize this photograph?" The defendant looked at it. For a moment, his face went blank, completely blank, as if he was processing something his mind hadn't prepared for. Then he said, "No, I don't recognize it." Marcus took a step back. He was giving the defendant space, giving him an opportunity. "This photograph shows someone who looks very much like you at Robert Hayes's house at 3:22 p.m. on the afternoon he died. Can you explain that?" The defendant's voice became quieter. "I don't know who that is. It's not me." Marcus nodded slowly. He walked back to the evidence table and picked up another photograph. This one was from a different angle. It showed the defendant more clearly. The features were unmistakable. "This is from a different camera," Marcus said. "It also shows someone at Robert's house at 3:22 p.m. This person is wearing the same clothes you wore that day, the same jacket, the same shoes. Can you explain that?" The defendant shifted in his seat. His composure was beginning to fray, not dramatically, but noticeably. "I wasn't there," he said. Marcus nodded. He walked back to the evidence table and picked up the location data report. "Your cell phone," Marcus said, "was at Robert Hayes's house at 3:22 p.m. Your phone connected to his Wi-Fi network. Your location data places you at those exact coordinates at that exact time. Your phone was with you, so either your phone was at Robert's house without you, which is impossible, or you were at Robert's house. Which is it?" The defendant didn't answer immediately. He looked toward his attorney. Sarah Chen was watching the testimony with the expression of someone who had known this moment was coming. The defendant finally spoke. "Maybe I went there. I don't remember." It was the first crack, the first admission, the first moment where the story began to shift. Marcus pressed forward. "You were playing a video game at home, but now you might have gone to Robert's house?" The defendant said nothing. Marcus continued. In your interview with Detective Torres, you said you were home the entire afternoon. You said you never left the house. You said you never saw Robert. Do you remember saying those things? The defendant nodded slowly. But now you're saying maybe you went there? The defendant didn't answer. Marcus walked to the witness stand and stood close enough that the defendant had to look at him. When you were at Robert's house at 3:22 p.m., what did you do? The defendant's face went white. He realized in that moment what had happened. He had been trapped. He had admitted to being at the house, and now he was being asked to describe what had happened there. His attorney stood. I object. The question assumes facts, not an evidence. The judge overruled the objection. The defendant was silent. Marcus waited. And in that silence, in that moment where the child realized he had been caught in his own lie, the courtroom understood something. The smile was gone. The composure was gone. What remained was a child who suddenly, terrifyingly, understood that he had lost control, that the performance was over, that the system which he had believed existed for him to manipulate was operating according to rules that had nothing to do with age or charm or the ability to maintain a false story. He realized too late that he had already revealed the truth, and the truth was going to destroy him. The victim impact statements came on the third day of trial, after the defendant's contradictions had been established, after the jury had heard all the evidence, after the certainty of guilt had settled over the courtroom like fog. The prosecution called the victim's family to speak, not as witnesses, not to testify about evidence, but to speak about Robert, to speak about loss, to speak about what had been taken from them. Patricia sat in the gallery before being called to testify, and she looked smaller than she had at the beginning of the trial. Not physically smaller, but diminished somehow, as if the weight of the past 3 months had compressed her down. Her sister held her hand as they waited. Neither of them spoke. There was nothing to say. They had said it all in the weeks and months after the discovery. Now they simply needed to say it again in front of a jury, in front of the man who had taken everything from them. Patricia took the stand and looked directly at the jury. She did not look at the defendant. She looked at the people who would decide what happened next. She began speaking about Robert, not about the day he died, but about his life, about the man he was, about the routines Patricia had depended on. Robert had checked on her apartment after her divorce. He had fixed her leaky sink. He had brought her soup when she was sick. He had remembered her mother's name and asked about her every time they spoke. He had been the kind of person who made the world better by existing in it. His voice, when she spoke, was steady, but underneath the steadiness was something else. A tremor, a depth of grief that couldn't be fully articulated in words. Patricia talked about the things she would never do with Robert, the conversations they would never have, the moments that would never happen. She talked about finding him in the garden. She talked about the moment she realized he was gone. And she talked about the fact that she would spend the rest of her life knowing that she had been the one to find him. When Patricia finished speaking, there was absolute silence in the courtroom. The judge sat motionless. The jury sat motionless. Marcus stood quietly, giving space for the weight of what had been said to settle. Then Patricia's sister stood. She spoke briefly about what Robert had meant to the family, about how his kindness had sustained them through difficult times, about how his absence was a hole that nothing could fill. She spoke about her sister and what she had endured. She spoke about the nephew who no longer had the man who had been like a grandfather to him. Her voice was quieter than Patricia's, but it carried an equally devastating weight. When she finished, she sat back down and held Patricia's hand again. The defendant's mother asked to speak. The judge allowed it. She took the stand and looked at the jury and began to cry. She spoke about her son, about how she didn't understand what had happened, about how this wasn't the child she had raised, about how she had lost her son as much as Patricia had lost Robert, because her son was gone too. He was sitting in that courtroom, but in every meaningful way, he was gone. A boy who had been 11 years old was now sitting in a courtroom facing charges that would define the rest of his life. She had lost her son. Patricia had lost Robert. And there was no winner in any of this. Only loss. Only grief. Only the terrible machinery of consequence moving forward, grinding unstoppable. When the defendant's mother finished speaking, she looked at her son for the first time since the trial began, and the child looked away. He couldn't meet her eyes. His composure, already fragile after the cross-examination, crumbled further. He realized in that moment what he had done to his mother, what he had done to his family. The weight of it seemed to finally touch him. For the first time in the trial, the child's face showed something that might have been emotion, something that might have been regret. But it came too late. It came after he had lied. It came after he had been caught. It came after the jury had already heard all the evidence and understood the truth. The judge called for a brief recess. As the courtroom emptied, Patricia sat in her seat and looked at the empty chair where the defendant would soon return. She had survived finding Robert's body. She had survived the investigation. She had survived sitting through the trial. She had survived hearing the evidence. She had survived listening to the defendant's lies. But she would not survive unscathed. None of them would. Robert's absence would shape the rest of her life. His absence would shape the life of his family. His absence would shape the defendant's mother, who had to live knowing what her son had done. His absence would shape the entire community, which had lost its faith in safety and trust. One person's loss rippled outward, touching everyone, forever changing the landscape of the lives it touched. When the court reconvened, the defendant was called back to the stand. But he was different now. The smile was gone. The composure was gone. What remained was a child who had finally begun to understand consequence, who had finally begun to feel the weight of what he had done. The judge looked at him and waited. There was still a sentencing to come. There was still a verdict to be delivered. But something had shifted. The jury had heard the family speak. The jury had heard the magnitude of the loss. The jury had been reminded that the person sitting in that chair had not harmed an abstraction. He had harmed a real person, a person who was loved, a person who was needed, a person whose absence would be felt for the rest of the lives he had touched. Silence becomes heavier than sound when it is the silence of a life that has ended. The courtroom was silent now with that weight. Judge Harrison waited until the courtroom had completely settled before he spoke. Everyone had expected closing arguments to follow. The jury had expected to receive instructions and begin deliberations. But the judge had decided something different. He had decided that before any of that could happen, something needed to be said. Something that had not been said in a juvenile courtroom in this state in decades. The judge removed his glasses and set them on the bench in front of him. He looked directly at the defendant, and then he began to speak, not with anger, not with judgment, with authority, pure, undeniable authority. The kind of authority that comes from someone who has spent 30 years understanding the law and the people who violate it. Before closing arguments, the judge said, before the jury receives instructions, I need to address something that has been implicit throughout these proceedings. There is a presumption in juvenile law that children deserve protection, that their developing brains, their relative lack of life experience, their fundamental difference from adults should shield them from certain consequences. That presumption exists for good reason. Children are different. Children are developing. Children deserve consideration that adults do not deserve. The judge paused. The courtroom was silent. Every person was listening. But, he continued, the law has never said that juvenile protection is absolute. The law has never said that age excuses everything. The law has never said that a child who demonstrates understanding, planning, and deliberate action should be shielded simply because of their youth. The judge stood. This was unusual. Judges typically remained seated while addressing the court. But Judge Harrison stood. He wanted the defendant to understand the significance of what was about to be said. The evidence in this case demonstrates something that occurs rarely in my courtroom. It demonstrates a child who researched his crime, who planned his crime, who documented his intent, who executed his crime with awareness of the consequences, who then lied about his crime with calculated precision. The psychological evaluation before this court demonstrates a child who understands the difference between right and wrong, who understands the impact of his actions, who chose his actions despite that understanding. Harrison paused. He let those words settle. He let them sink into the jury's consciousness. He let them sink into the defendant's consciousness. There is a statute in this state, the judge continued, that allows for certain juveniles to be tried as adults when specific criteria are met. That statute has been invoked in this case by the prosecution. That statute exists precisely for situations like this one, situations where the protection extended to children would become a shield for someone who has demonstrated that he does not deserve that shield. I have read the statute. I have read the precedent. I have read the evidence, and I have reached a conclusion. The judge sat back down. He placed his hands on the bench. The defendant will be tried as an adult in these proceedings. The protections afforded to juveniles will not apply. Any sentence imposed in this case will reflect the severity of the crime and the defendant's demonstrated understanding of that crime. The courtroom erupted, not with sound, but with movement. The defendant's mother put her hand to her mouth. Sarah Chen leaned over and began speaking urgently to her client. The prosecution allowed themselves a moment of visible relief. The judge raised his hand, and the courtroom went silent again. "This is not a decision I have made lightly," he said. "I understand that it is unusual. I understand that it will be appealed. I understand that it will be controversial. But I also understand my obligation to apply the law as written, and the law as written allows for this decision. The law as written allows me to recognize when a juvenile has demonstrated capacity beyond his years. When a juvenile has demonstrated understanding, planning, and deliberate action, when protection would become corruption of justice. The defendant's composure, which had been barely held together, completely shattered. He began to cry, real tears, real emotion. For the first time in the trial, the performance ended completely. The mask was gone. What remained was a child who suddenly understood that his belief in his own specialness, his belief in his own superiority, his belief that the rules didn't apply to him had been fundamentally wrong. The system was responding to what he had done, not to who he believed he was. The judge was not moved by the tears. The judge had seen tears before. The judge understood that remorse that came only after being caught was not the same as remorse that preceded crime. The judge continued speaking, his voice steady. The court recognizes that the defendant is 11 years old. The court recognizes that his brain is still developing. The court recognizes that children are different from adults. But the court cannot ignore that the defendant made choices, that the defendant made plans, that the defendant executed those plans with awareness of consequence. The court cannot ignore the evidence. The court cannot ignore the victim's family. The court cannot ignore the fundamental principle that justice requires accountability, regardless of age, when the evidence demonstrates this level of deliberation. The judge paused. He looked at the defendant. You will be held accountable for what you have done, not because you are evil, not because you are inherently bad, but because you made a choice. And choices have consequences. Sarah Chen stood and asked for a recess. The judge granted it. As the courtroom emptied, the defendant sat at the defense table with his head in his hands, his entire body shaking. His mother wanted to approach him, but a bailiff gently guided her back. The defendant had been held to adult standards. The defendant had been denied the protection that juvenile law typically afforded. The defendant had been told in front of a courtroom full of people that his age would not save him, that his belief in his own specialness had been wrong, that the system, which he had been so certain he could manipulate, was operating according to principles that had nothing to do with him. The gavel hadn't fallen yet, but the direction was clear. History was being written in that courtroom. A precedent was being set. A judge was deciding that sometimes accountability matters more than age. The jury had taken 6 hours to reach a verdict, 6 hours to deliberate the evidence, 6 hours to discuss the implications, 6 hours to arrive at the only reasonable conclusion the evidence allowed: guilty. On all charges. The verdict had been read on a Thursday morning. The defendant had shown no reaction. He simply sat in his chair and accepted the words, guilty, as if he had always known this was coming, as if his earlier tears and his broken composure had been just another performance, just another calculation about what the jury might respond to. The judge had scheduled sentencing for the following week. 7 days for the probation department to prepare a sentencing report. 7 days for the prosecution to prepare their sentencing argument. 7 days for the defense to prepare their mitigation case. 7 days for the community to brace itself for what was coming. On the day of sentencing, the courtroom was even more packed than it had been during trial. The media knew this was the moment when the judge would decide what happened to the defendant for the rest of his life. The outcome wouldn't change what had occurred, but it would shape what happened next. It would establish precedent. It would demonstrate whether age would be a shield or simply a factor to be considered. Patricia sat in her usual seat in the third row, accompanied by her sister and her ex-husband. They had come to hear what the judge would say. They had come to hear what consequences looked like for someone so young. They had come to understand whether justice had been served or whether they would be disappointed by leniency they couldn't accept. The judge entered. Everyone stood. Judge Harrison moved to his bench and sat. He looked out at the courtroom. He looked at the prosecution. He looked at the defense. He looked at the defendant sitting in his chair, smaller now than he had appeared at the beginning of trial. Something in the proceedings had diminished him. The weight of the verdict, the weight of being found guilty, the weight of facing consequences that could no longer be denied. The judge had written his sentencing statement over the course of the week. He had considered precedent. He had considered the defendant's age. He had considered the evidence. He had considered the impact on the community. And he had reached a decision that he knew would be significant. "Before I announce the sentence," the judge said, "I want to speak directly to the defendant, not as a judge speaking to a criminal, but as an authority figure speaking to a child who has made choices that require accountability." The judge paused. He was choosing his words carefully. "You came into this courtroom believing that your age would protect you. You came in believing that the system could be manipulated. You came in believing that the rules didn't apply to you. But you were wrong on every count. The evidence didn't care about your age. The jury didn't care about your performance. The law didn't care about your belief in your own specialness. The system applied itself fairly and equally to the evidence, and the evidence was overwhelming." The judge continued, "You took a life, not accidentally, not impulsively, but deliberately, with planning, with research, with awareness of the consequences. You hurt a family, you hurt a community, you hurt your own family, and then you lied about it. You lied to the detective, you lied in your interview, you tried to lie to this court, but the evidence wouldn't let you lie. The evidence kept speaking truth." The judge looked directly at the defendant. "I cannot give you the punishment you would receive as an adult. The law prevents that. But I can give you a sentence that reflects the severity of what you had done. I can give you a sentence that acknowledges your guilt and your deliberation." The sentencing was announced. The judge sentenced the defendant to 25 years in the juvenile justice system, with a review for potential transfer to adult facilities at age 21, dependent on behavior and progress. It was unprecedented. In all the history of cases in this state, no 11-year-old had received a sentence this severe. It was legal. It was within the judge's authority, but it was historic. The defendant showed no reaction as the sentence was read. He simply sat there. His mother began to cry, not because she was unsympathetic to what her son had done, but because she was crying for the child she had lost, the child who would spend the next 15 years in a facility, the child who would not experience a normal adolescence, The child who would carry this conviction for the rest of his life. Patricia began to cry quietly. Her sister held her hand. They had heard the sentence. They had heard the judge validate their grief by taking seriously what had been taken from them. Robert's absence would be permanent, but so would the defendant's consequences. So would the mark on his life. The justice that had been served was cold. It was not satisfying in the way that vengeance might be, but it was justice. It was accountability. It was the system responding to what had been done with appropriate weight. The judge looked at Patricia. He saw her tears. He understood what they meant. He had done what he could within the law. He had recognized the severity. He had responded with consequences that matched the crime. As the bailiff stood to escort the defendant from the courtroom, the child stood, and for the first time he looked truly young. All the performance was gone. All the composure was gone. What remained was an 11-year-old child who had made a choice that would shape the rest of his life, who had believed in his own invulnerability and had been proven wrong, who had thought the system could be manipulated and had been shown the truth. He was led away. His mother sat alone in the gallery, her face in her hands. The gavel fell. The sentence was official. The trial was over. What happened next would be written in facilities, in courtrooms, in the defendant's own future choices, and the degree to which he might someday understand what he had done. The courtroom began to empty. The press rushed toward the exits to report the sentence to the world. The family of the victim remained in their seats for a moment longer, breathing in what it felt like when the machinery of justice finally stopped moving. When the verdict was delivered, when the gavel fell, when it was done, the case became what legal scholars would later call a landmark decision. Law journals published articles about it. University professors taught it in criminal justice classes. The decision to try an 11-year-old as an adult in this state set a precedent that would be referenced in future cases. The question of whether age should shield a child from accountability when that child demonstrates understanding, planning, and deliberate action became a central topic in debates about juvenile justice. Some argued that the sentence was too harsh, that the judge had overstepped, that an 11-year-old could never truly understand the consequences of his actions. Others argued that the case demonstrated something important, that accountability could not be relative to age alone. That evidence mattered. That planning mattered, that the difference between a child who made a terrible mistake and a child who made a deliberate choice was significant. The country was divided. The community was divided. But one thing was certain. The case had changed something. It had changed how people thought about children. It had changed how people thought about responsibility. The defendant was transferred to a juvenile facility 3 hours away from his community. His mother visited him for the first month, then less frequently as the months turned into years. He attended school within the facility. He participated in programming. He met with psychologists who attempted to help him understand what he had done. Gradually, over time, something shifted in him. Not immediately. Not in the first year or the second year, but eventually, in the way that time changes everyone, he began to understand. He began to read about Robert Hayes. He began to understand that Robert was a real person, a person who had done kind things, a person whose life had been stolen, a person whose absence was permanent. Whether this understanding came from genuine remorse or from the kind of maturation that happens when a child is forced to face himself every single day, no one could say. But it came, and it changed him, not to the point where anything could be undone, not to the point where he would ever be the same person he had been before trial, but to the point where he began to understand himself differently. Patricia went back to work after 6 months. She took a leave of absence, and when she returned, she was not the same person. No one expected her to be. The loss of Robert had carved a hole in her life that couldn't be filled, but she learned to function around it. She learned to exist in a world where Robert was no longer present. She visited his house occasionally. Someone else lived there now. They had painted over the fence where Robert's garden had been. They had removed his tools. They had erased the evidence of him from the space he had loved. Patricia found this harder to accept than the trial itself, the erasure, the way the world moved on and forgot. But she didn't forget. She visited Robert's grave on holidays and on his birthday. She brought flowers. She sat for a while and thought about the conversations they would have had, the moments that would never happen, the life that would never unfold. The community slowly returned to something resembling normalcy. But it was not the same normalcy as before. The trust that had existed was gone. Parents were more cautious about which adults their children spent time with. The neighborhood watch became more active. The sense of safety that had been built over years was destroyed in a moment and could not be rebuilt. Children still played in yards, but they were watched more carefully. The ease that had existed was replaced with vigilance. The innocence was replaced with awareness. Robert's absence created a permanent change in the landscape of the neighborhood. His house sold to people from out of state who didn't know the story. But the people who lived there knew. The people who had been there before knew. They would know for the rest of their lives. Judge Harrison continued on the bench for 3 more years before retiring. The case he had presided over followed him into retirement. He was invited to speak about it at law conferences. He was asked about his reasoning. He was asked whether he would make the same decision again. His answer was always the same. Yes, he had applied the law as written. He had considered the evidence. He had recognized accountability. He had not allowed age to become a shield for someone who had demonstrated he didn't deserve shielding. His retirement was quiet. He did not live long enough to see the defendant's release hearing, which would come when he was 28 years old. But he had set something in motion. He had established that sometimes the system could move beyond assumptions about age and respond to the specific facts of a specific case. The media coverage eventually faded. The case was no longer trending. New crimes occurred. New trials began. New victims' families sat in courtrooms. The case that had dominated the news cycle for months became history. But history that people still referenced, history that still shaped how people thought about juvenile justice, history that still mattered. The defendant, in his facility, lived out his sentence. He earned his GED. He participated in programming that attempted to rehabilitate him. He began to age. The 11-year-old who had smiled at the courtroom became 12, then 13, then 14. He grew, his voice changed, his body matured. And somewhere in the process, the person who had committed the crime became someone different. Whether that person was capable of genuine remorse, whether that person truly understood what he had done, no one could say with certainty. But the question of his capacity for change became relevant in a way it hadn't been at trial. In the years after sentencing, technology changed. Social media evolved. New platforms emerged. The case that had been covered by traditional media was discovered by new audiences on the Internet. Videos of trial clips were uploaded and viewed by millions. The defendant's identity, protected during trial, became known. People tracked his progress in the facility. Some advocated for his eventual release. Some argued he should never be released. Some simply watched, documenting his life from a distance. The defendant, who had believed he was special, who had believed the rules didn't apply to him, discovered that he was being watched by thousands of strangers who all had opinions about his future. On a spring afternoon, 17 years after he had walked into that courtroom with a smile, the defendant stood before a parole board. He was now 28 years old. He had spent more than half his life in the facility. He had changed, visibly, psychologically, or so the reports suggested. The parole board listened to testimony from psychologists. They listened to the defendant speak about his understanding of what he had done. They listened to arguments from both sides, and they made a decision. He would be released, with conditions, with monitoring, with the understanding that if he reoffended, he would return to serve the remainder of his sentence as an adult. The defendant had received what he had always believed was possible, a second chance. But not the second chance he had believed he deserved, a second chance earned through time and programming and perhaps genuine change. Patricia received a notice of the parole decision. She read it in her living room and felt something she hadn't expected to feel. Not rage, not satisfaction, just sadness. Because Robert was still gone, because no parole decision could change that, because the defendant's release didn't bring her neighbor back. It didn't restore the life that had been stolen. It didn't erase the years she had lived with grief. The smile from the courtroom was long gone now. The arrogance was long gone. What remained was a man who would live the rest of his life knowing what he had done. Who would live knowing that he had taken someone from the world. Who would live with that knowledge every single day. That, perhaps, was the real sentence. Not the years in the facility, but the knowledge itself, the awareness, the understanding that time doesn't erase certain acts. It only makes you older. It only gives you more years to think about what you've done. It only gives you more time to understand the magnitude of your choice. He smiled at the court, until the court reminded him who never blinks. And the court never stopped watching. The court was watching still.